All right, everyone. Here we are. Last class. Not like the fake last class last time, but the real last class. Let's see. Does anyone have any questions before we start? Anything, other issues? Okay. Now, not many of you actually sat through to take the exam here, so I assume the rest of you took it at home? Yes? Okay. So before I begin, did anyone have any problems with the timing? Was time a factor for anyone? Okay. Was the word limit a factor? Okay. We'll work on that. Here you go. Okay. So let me explain a little bit why I do the timed word limit. I think I've discussed this before. Everyone has different speeds, right? Everyone writes at different clips. People have different memories. Some people, if no word limit, can dump thousands of words on the paper in the hope that something will touch upon something done in class. I was one of those students. I was very good at it. I could write 3,000 words in a 3-hour exam. I timed it. That doesn't teach anything about whether you know your stuff. Okay. The reason why I have the word limits is to judge everyone on an equal playing field. If everyone's given the same amount of words to do something, it's very easy to compare an A to a B. Okay. But even more important than that, it allows me to know that I can see which points you're hitting and which points you're not. You have to actually make strategic points and strategic arguments. And you might say, why am I ever going to be limited by word counts? Well, any brief you ever file in any court will have a word limit, and it's not going to be nearly enough. Now, you might say, oh, 1,000 words is nothing. You can have briefs that are 5,000, 6,000 word limits for an entire brief, top to finish. So it's actually fairly generous. One other point I want to stress is that you don't need 100% to get an A. You do not need to get 100% of the issues to get an A. Not even close. I'll never forget, and this is not an example, but when I took Civ Pro in law school, it was the hardest exam I ever took. It was harder than the bar. It was this fact pattern I'll never forget. It involved a car accident on a bridge between two states in which there were federal bonds in the backseat of the car. It was evil. And there was an issue where there was some sort of document which was certified in France, and we had to apply the California Civil Procedure Code to figure it out. It was evil, right? I think I got like a 70 on the exam, and I got an A. I was like, oh, okay. So everything is curved. If you are having trouble with it, your colleagues are having trouble with it also. Okay. The thing professors don't like to tell you is the reason why you give a tough exam is to get a nice natural curve, right? An easy exam gives a very flat curve, which doesn't work very well at all. Okay? The tough exam allows you to show that maybe you know this topic well and that topic not as well, but you can at least show your stuff off. A simple exam, which tests some fewer issues, gives you less of an opportunity to exemplify that you learned material. So that's some of the thinking behind why I structure the test the way I do. And you guys are lucky in property, I have a 500-word limit. So here I have 1,000. The reason why is I want you to actually discuss some policy issues which really are not concerning me so much in property. Okay? Any questions before I begin? Okay. So I'm actually going to do the screen share so people watching at home. Yes, Melissa?
Will this be representative of the difficulty level of the final? Or?
Yes. Yes. The question was, is this sample exam representative of the difficulty of the actual exam? Yes. It's going to be at the same level. Again, I haven't written your exam yet. That's been deliberate. I don't want to prejudice myself by inadvertently leaking a fact, but this will be in the same fashion as the exam. All right? So you're on your own as far as how you decide to begin the exam, but this is what I'd recommend. The very first page are the instructions. There's an old expression called RTFM. Anyone ever hear about that? He knows what it is. What does it stand for? It's going to setting them up. Yeah. Yeah. Read the effing manual. Okay. Read the instructions. You will not go wrong by reading them. Now, these instructions here, this will be verbatim on what's your exam. So I've actually given you the first page of the exam already. You have it in your possession. I promise I copy these every year verbatim. They're exactly the same. But more importantly, go down to what I call the prompt. Okay? These are the actual questions. These are the actual instructions for the question. And this will put you in the right frame of mind to understand what I'm looking for. So from the very first sentence, the year is 1936, right? So you should say, okay, we're at some period in the past. Again, I've said this many times. You're going to have one question in the present day, 2014, and you have one question at some historical juncture. I gave you the list of them before, but it's going to be like, at the time of the founding, before the Civil War, during the Civil War, after the Civil War, turn of the century, during World War II, during the New Deal, during the Civil Rights era, during the modern era. There's a finite number of periods which we've discussed at various points, and I recognize most of the faces in this room, so you've all heard them. Some faces I don't recognize as much. So, you now the year. Okay, so what happens? Okay, so we have President Roosevelt, right? We all know about his New Deal programs. He has this new law called the Health Security Act of 1934. A side note, this is actually what Hillary Care was actually called. The official name for Hillary Care was the Health Security Act. So, we'll put that together. Very good. Okay. You are a law clerk for Justice McReynolds. People ask me, what do I need to know about the justice? Well, I'm going to give you hints. I'll say he's one of the conservative four horsemen. That should be enough to trigger your memory. And also, it should be enough that you should know that he's the one who strikes down Roosevelt's laws. Okay. I write that a case challenging the constitutionality of the law was just argued. Okay. We have to write a memo of no more than 1,000 words, addressing 5 specific issues. And excuse me, for the exam, I promise I'll do something like this. There'll either be 5, or maybe 7, or 10, or probably 5 to make it easier to count, discrete issues. Okay? I want you to tell me about these issues. I don't want you to go off and give me lots of other stuff. Okay? So after you read the very beginning, what I'd recommend is scroll down, or actually, paper you can flip. It's funny. You ever see the video of the little baby with the magazine? She's swiping the magazine, and she can't figure out why the page won't turn? Yeah, that'll be us soon. It's not working. Anyway, so after you read the instructions, scroll down. You'll see I do this little dash thing that kind of breaks apart the question. Go to the actual prompt, right? Remember in your essay classes in high school, the prompt the question. What am I asking you to do? So it says here that McReynolds was assigned to write the majority opinion, okay, on behalf of himself and the 4 horsemen and Owen Roberts, who of course was our swing judge. And he asked you to a bench memo addressing the 5 issues. Okay? I'm going to say something like this usually because I want to see what you think. I don't really care what McReynolds thinks. You know how McReynolds is going to vote. He's going to strike it down. There's no question. But you have an independent mind. I want to see what you think objectively is the correct answer based on precedents in 1936. Right? I'm not concerned with what you think the judge is going to do. In this question, I want to know what do you think. And either way is fine. I don't have any predisposition to any answer. I want to see what you think objectively. Again, I repeat the word limit, 1,000 words. Don't go over. Don't do it. I'll stop reading. It's not fruitful for you to do that. You can edit down if needed. Okay. So this one is somewhat misleading, but not so. There are 5 issues, and they're each worth equal value. But invariably, there's going to be one issue that probably has more to write about than the other. That could be based on how I write the question, or maybe you might know more about one issue than the other. If that happens, you can adjust. Maybe make it instead of 200 words, 200 words, 200 words, make it maybe 300 and 100, right? You can adjust that yourself, and I don't have any prescription of how to do that. But you should let your own knowledge guide you. So say you know Commerce Clause really well, and you don't know much about federalism. Write more about Commerce Clause. Try and get all 10 of those points, right? Because I think I said there are 5 issues. Each issue is worth 10 points. So try and get all 10 of the Commerce Clause points, maybe get 7 or 6 of the federalism points. You can balance yourself out. Okay, so again, there are 5 issues. Each issue I grade a scale of 1 to 10. Makes it very easy. 10 is perfect, 0 is blank, and everywhere else in between. The first issue asks about commerce and necessary and proper. Okay, those issues usually go together, but they're not the same thing. We'll discuss that when we go over the answer. The second issue discusses the taxing power. Is that a hand up?
Yes.
Okay. The second issue discusses the taxing power. Okay. Third issue is due process clause of the 5th Amendment. Note, not 14th, 5th, but hopefully you all address that in your answer. Because we're talking about the feds here, not the state governments. The fourth issue is whether it violates the 10th Amendment or principles of federalism. Okay, keep that in mind. And then the last one I'm always going to have some question like this. This is what I kind of call the policy question. It's not going to be a straight up black letter law. This won't be in your board book. This is going to be based on some discussions we've had in class, discussing some of the more policy-oriented issues. For example, we talked a lot about changing votes. We talked about it in the New Deal. We talked about it with Obamacare. We talked about it in Planned Parenthood versus Casey. So you have a lot of exposure to these kind of issues. You can think of the other issue we talked about, in times of war, laws fall silent, how the courts reacted to civil rights cases, should they have struck more stuff down, how they proceeded deliberately in Brown, how perhaps the court went too far in Roe. These are these kind of meta issues which we spent a lot of time talking about. And these are the kinds of things which you should be thinking about. Okay? All right, so you get down to the bottom. Then we start reading the facts, because at this point, you know you're going to have to be looking for a couple key things. You're looking for commerce, you're looking for necessary and proper, you're looking for tax, you're looking for due process and federalism, and some other thing about changing votes. So this focuses you or frames you where you're going to go. Okay, hello, good. So we begin. I'm almost always going to give you some piece of legislation. And I appreciate most of you have never actually seen a piece of legislation before. In fact, for some of you, this is probably the first time I've actually seen a statute in this form. That's fine. There's nothing wrong with that. I'll give you everything you need to know. There's no secret. So it begins. The Health Security Act of 1934 has the purpose of ensuring that all Americans have access to affordable health insurance. Now, I'll give you a hint. I copied this up almost verbatim for Obamacare. I changed some words around, but this is almost verbatim Obamacare. Like, word for word, I changed a few things so it makes a little bit more sense. Okay? Here you go. Oh, yeah. All right, so we have now Section 1. Again, and this is exactly verbatim from Obamacare. A requirement to maintain minimum essential coverage. Okay? There's a curveball in the very first sentence. I hope somebody picked up on this. The law was enacted in 1934. The year is 1936. When does it? The year now is 1936. When does it go into effect? 37. Okay. This was actually the Obamacare issue itself. I hope somebody picked up on this. The suit isn't even ripe, right? Depending how you read it, the suit won't even go into effect yet. So that I mentioned at the end, but always be on the lookout for those kind of lurking issues. Like that will make an 8 answer like a 10, right? That will bump it up so that, wow, okay, they picked up an issue that has absolutely nothing to do with the commerce laws. Okay, and we discussed that issue ad nauseum with Obamacare. Okay, so it says, after January 1st, 37, a person of the age of 18 shall ensure, that's actually the language from Obamacare, shall ensure that he has a qualified health plan. And then it says, the Labor Department shall publish a rule defining what constitutes a qualified health insurance plan. This wasn't in the question directly, but this should raise flags about the non-delegation doctrine, right? We know that when Congress gives an administrative agency the authority to make a rule, they have to give some sort of guidance. Here, is there any guidance defining what a qualified plan is? No, there isn't. And again, this is when Schechter Poultry, remember the sick chickens case, this was still good law. So it wasn't directly on point, but that's something else to pick up and think about. Okay, so that's Section 1 of the law. We scroll down. Section 2. This is, again, almost verbatim from Obamacare. The shared responsibility payment. If a person fails to maintain a qualified health insurance plan, then there is hereby imposed a penalty of $1 a month. The penalty shall be paid to the Internal Revenue Service with the person's annual tax return. Okay, so this should start flagging in your head, wait a minute, is this a tax or is it a penalty? Now, I copied this verbatim from Obamacare, so that won't answer your question. But I think you can make arguments on either side, right? On the one hand, it says penalty. On the other hand, it says you pay it to the IRS with your tax return. And it's only $1 a month. It's not particularly high. It's a small amount, even 1936. So in your mind, you think, okay, this probably addresses the second question about whether this is a valid tax or not under the taxing power. Okay. Questions so far? Okay. Section 3. Okay. This is again almost verbatim from Obamacare. The state exchanges. All states are required to set up these exchanges to allow people to buy health insurance. But thank God there was no internet back in 1936. They have to actually have stores, right? A store where people can go in an office in the state capitals, and these offices have to have navigators, that's what they're called, who can assist people in signing up. So this is a requirement for states to open up these stores and hire these so-called navigators. Okay. Now, we don't have the commandeering cases. For example, Prince hadn't been decided yet for 60 years. But we do have the 10th Amendment. And we do have principles of federalism. So there are certain things in your toolkit which you can address to it. And you can even mention that this is effectively commandeering or commanding the states to do stuff. So you can address that also. Okay. You come down. Stop me if you have any questions. Yes?
So I guess
Somebody stop me, right?
Try to sort of insert Prince in there without not
Yeah.
really doing it. That's the best way to do it.
You'll see what I did with the sample answer, and you can compare it to what I did. But yes, that's right. Melissa?
Can you make a parallel with Butler?
Sure. Yeah. How so?
Well, there they were forcing farmers as individuals, and here they're forcing the states. So if you can't force individuals, why should you be able to force states?
That's not a bad argument. Yeah, that's not bad. Yeah, that's pretty good. Jared's fist pumping, so we know he's in Jersey right now. So we come down to Section 4. Okay, this is called the Agricultural Readjustment Act. You might remember that the original act was called the Agricultural Adjustment Act. That was the name of the law in Wicker v. Filburn, right? So it says Congress makes a finding that broccoli. Oh, I had to ask about broccoli. That broccoli is the most healthful vegetable, and they seek to stimulate its production and consumption. Okay. All private schools are required to teach students that they should eat broccoli daily. So, what cases did we do discussing education? Well, that was Pierce v. Society of Sisters and a little bit of Meyer v. Nebraska, right? They can't ban private schools. They can't tell kids they can't study German. The state has no power to do that. Okay. The next sentence. So, further, all children in the age of 18 in the public and private schools are required to eat one serving of broccoli for lunch every day. So, I mean, there's a couple issues here. One, the feds are forcing the states to change how they manage education, right? At this time, for sure, education was a matter of state concern. It was not a matter of federal concern. Yep, this would be some sort of coercion also. But more importantly, they are compelling individuals, children, to be forced to eat broccoli. And as a matter of due process, that's my bodily integrity, right? They can't shove something down my throat. Although you may say a response, well, if they can sterilize me, cut up my fallopian tubes, and sure they can make me eat broccoli, and that might not be the wrong answer. Then it says the last one, for every day the child refuses, the child's parent is required to buy broccoli. So now we also have a due process issue for the parents who are being compelled to purchase something. Okay. Now note in the prompt of the question I say Fifth Amendment due process only. I did not ask about the Commerce Clause here. I even said specifically that's the only provision I'm raising. Now, you can write about Commerce Clause. Broccoli is on commerce. The schools are in one state. But I already asked you about commerce. I only asked you here about due process, and I want you to focus on due process. So don't go astray if I don't ask you for it. If I specifically say only do due process, that's all you have to do. All right, I think that's the last section. Yeah. All right. Have you with me so far? Questions? Okay, good. Okay, so the minutes after Roosevelt signed the act into law, this is just like Obamacare. There were lawsuits filed minutes later. We have 3 lawsuits filed. So I promised you in any question, there's going to be some law, and there's going to be different people who challenge it for different reasons. Okay? You need to look at each party independently for a couple reasons, one of which is going to be standing. There's going to be a standing issue buried somewhere, and it's not going to be obvious. And I don't need to ask about it either, right? Why? Because standing is jurisprudential, jurisdictional, right? Standing is jurisdictional, we say. If the court lacks standing, they can't hear the entire case. Okay? I will caution you, though, if you find that there's no standing, go ahead and do the analysis assuming there is standing, okay? Because you don't want to be wrong about that, right? You don't want to say there's no standing, therefore the entire case is dismissed. You don't want to be wrong about that. You say, assuming there is standing, let me give you the analysis. Don't blow that one, okay? And for people not here, they'll lose that thing. But don't say there's no standing, therefore the case is over. Jared?
Can you put standing at the end? I mean, that's what
Yeah, you can do whatever you want,
okay.
but address it wherever you want. But I would strongly put it this way. I'm not going to give you this lengthy fact pattern where the answer is no standing, therefore it's dismissed right away. That's not going to be the answer. I promise. Melissa?
Do you want us to address standing with each individual person?
You can, although I'd probably stress if it's obvious they're standing, you don't need to mention it. But you're welcome to. You're welcome to. Okay? All right, so the first lawsuit. Why is standing important? Because it's not brought by an individual. Okay? Now, the Liberty League, who has ever heard of the Liberty League? This was like the Tea Party of the New Deal. These are actually these very wealthy, funded corporate groups who tried to oppose the New Deal. These were the Tea Partiers back in the 1930s. It's actually a real group. And they consisted of all these basically people who opposed the New Deal. So it says, the first lawsuit filed by the Liberty League, a private group, opposed the New Deal. Okay. We've done this. Can entities, corporations, bring standing on behalf of individuals? The answer is yes. Okay. When did we do this? For example, we had the abortion cases. Remember Planned Parenthood versus Casey? The case was brought by Planned Parenthood on behalf of their member doctors, right? We did cases with the ACLU, right? The American Civil Liberties Union. They brought cases on behalf of people. Okay. The New York Times or Sullivan, right? They could bring suit on behalf of different people. So there's nothing wrong with having a corporation or an entity bring suit on behalf of its members. I'll explain it a little bit more detail in the answer, but that's no obstacle. Okay? So it says this Liberty League, they challenge sections 1 and 2. Pay also attention to which sections they're challenging, because each section is challenged by a different party of the health of the HSA. They say that it's bad under commerce, necessary and proper, and taxing power. So that tells you those are the first two issues, the first two prompted questions. Okay, so then number 2, we have Roscoe Filburn. Of course, he is the eponymous plaintiff in Wickard v. Filburn. He is an Ohio farmer, and his 13-year-old son, I don't know that he has a son named Frankie, but I'll make it up. Maybe when Frank went to Hollywood, perhaps. Frankie Filburn, okay, they filed suit, and they're only focusing on section 4. They say they hate broccoli. They don't want to eat it. They want to buy it. And also he makes a claim about the private school. He doesn't want to force a private school to teach about the horrors of broccoli. I mean, these are terrible things. Important. They both assert that Section 4 violates the Due Process Clause. This is the only provision they raise. I know you want to tell me about commerce, but that's not the place here. Okay? I want you to focus on due process. Okay, so then we come down to number 3. It says the AG of Texas files a suit challenging Section 3. This was the exchange section. And they're alleging that by forcing Texas to open the exchanges and hire the navigators, they're intruding on Texas' sovereignty, and they're violating the 10th Amendment. This, again, is this has happened in Texas also, where basically the federal government basically opposed the creation of these exchanges. Okay? All right, so everyone okay with the facts so far? Any questions? Anything? All right, 2 of these. Good. All right, so we come now to the next part. It says, okay, all the challenges are rejected in the lower court. This is up to the Supreme to decide. Okay, so this is where the wrinkle comes in. This is where the policy issue comes in. So it says, shortly after the case is argued for the court, President Roosevelt, in one of his fireside chats, everyone knows about these, he would have these, I mean, there was no TV, there was radios, but he would apparently sit in front of a fireplace and talk to the American people and explain to them why he needs to do what he needs to do. He announces his court packing plan. We discussed this a number of times, that this would give him the power to appoint a new justice for every justice over the age of 70. This would give him effectively 5 new picks, 14 justices, and he would have a balance in the court in his favor. So basically, this law will pass, and he can do whatever he wants. Okay? Everyone get that so far? Okay. Then we learn that Justice Owen Roberts, who in the past, God, history has a sense of humor with that one. I laughed when I found that. I was like, Roberts, yes. So Owen Roberts had found the program unconstitutional in the past, and he tells his justices, you know, I think this law is unconstitutional. This is the worst thing ever, but I don't want to have a clash with the president. This might impact the court's legitimacy. I don't want to drag this court into a fight during the New Deal. And this sentence, I think this is actually a quote from my book. Justice Roberts is wavering about whether he will uphold the president's signature piece of legislation. So he's on the fence. So we go down. Okay, we read this part already, but you're assigned to write the bench memo and do so objectively. And again, we read these 5 parts, which I'll re-summarize. Part 1, commerce is necessary and proper. Part 2, tax. Part 3, due process. Part 4, 10th Amendment. In Part 5, Owen Roberts, right? So there are 5 parts, each worth 10 points. You have 1,000 words total. Ballpark, 200 words apiece. Ballpark. It's not precise. Okay? All right. Before we start, any questions? Yes, sir.
I don't think like it matters, but do you grade each one entirely, or do you do one question compared to all?
I grade Part 1, I grade on a scale of 1 to 10. I grade Part 2 and grade on a scale of 1 to 10. I read Part 3, grade on a scale of 1 to 10.
Okay.
I mean, literally, when I'm going through it, after each part, I put a number.
So the only thing I'm not complaining, saying something that seems odd, because you can address all of the standing issues in question 5,
Mm-hmm.
and it's clearly showing you have all the knowledge of why the standing is a problem.
I go back and change the score sometimes. If, for example, like, why didn't he say it here, and I give you a low score in Part 1, they say, oh, he did it in Part 5, I can readjust the scores. Yeah, they're not set in stone.
Some people only grade all the ones in every single test.
I thought this through, right? I mean, there are pros and cons. The reason why I'd rather grade as I go along is I might forget stuff. This allows me to easily, I take notes also. It takes me about 15 to 20 minutes to grade an exam. Actually, it'll be longer for 1,000 words. But for property, it takes me 15 to 20 minutes to read one paper. And I take notes along the way, and I explain why. So that's why as I go along, I score. But if I realize that you hit something later that was probably written early, I'll give you more points. Yeah, no, don't worry about that. Okay. All right, so here I chose to address the standing in the very beginning. This is an associational standing, and this is actually the test, more or less, that we discussed, the second or third day of class. Okay, remember, there has been injury in fact. You have to prove some sort of causation, and that the actual injury will be fixed by a favorable ruling. And the fact is, the members of the Liberty League oppose this law. They're all going to be impacted by it, and a ruling striking it down would actually benefit them, so they're not having to pay this tax penalty hybrid monster. Are we okay with that? Okay. So I say right away, this is not a valid exercise of Congress's commerce powers. And I give a brief sketch of the precedents. And this is where, if you do rule statements, or you kind of summarize your cases into like simple rules, this is where it comes in handy, because you can just copy this straight from your outline, right? Why does this violate the Commerce Clause? Well, we need to talk about a couple cases, specifically the cases in existence in the 1930s. So about Gibbons, right? Gibbons, in one sentence, Gibbons defined commerce very broadly as intercourse among the states, even what's wholly within one state. Then we talk about E.C. Knight. This is when the court started changing the direction. They said that manufacturing is not commerce. This invades the power of the states and violates the 10th Amendment. Okay, then we have Hammer. This was a child labor case. They struck down this tax on, they struck down the law banning the child labor goods. Manufactured goods is not commerce. Carter versus Carter Coal, we talked about many times. This discussed coal. Merely mining coal is not interstate commerce. Okay? So all of these cases more or less establish that health insurance by itself is not commerce. Okay? What you didn't know was there was actually a case decided in the 1940s called Southeastern Underwriters, where the Supreme Court effectively reversed it and said that insurance is commerce. There was a case called something from the 1860s that I didn't sign, but the Supreme Court actually held that insurance is not commerce. Okay? For good measure, and they weren't even applicable here, but Congress also has the power to regulate the instrumentalities, which is the Shreveport raid case, and the channels of commerce, which was the Champion versus Ames, a lottery ticket case. So in basically a paragraph, you can sketch most of the Commerce Clause precedents which you need to know, and we've discussed all these at length. Okay, so then what's my conclusion? Okay, all these cases support the conclusion that health insurance sold and used in one state, which is what's at issue here, is non-article, instrumentality, or channel of commerce. Congress does not have the power to regulate it. All right, questions on that? Yes, sir.
I was wondering, when I was first going through it, I didn't know, I guess, how much I was going to write yet. So I was pretty frugal with how many words I used, and I didn't do so much citing cases as my first few sentences were summing up, I guess, what you could do at the time, like you could do a totality challenge, whatever, you can do this and that, but I didn't like cite cases.
If you can cite cases, even a parenthetical, right, just in parentheses, one word Shreveport, that makes it a lot better. So now that tells me you know your cases. A related comment, don't worry about being frugal so much at the beginning. Write out your answer, and then you can edit later. My initial answer for this was probably twice as long to edit it. Write out your answer, and then edit it. You'll be better off. I mean, if you're running short on time, then that might not be a good strategy. But if you found that you had time left over, that might be a better strategy. We'll say, hand us up.
Like the way that I answered it was I put up like what the government may argue, and then I said, well, this isn't going to work, and I explained why.
That's fine. Yeah.
That's fine.
Yeah. There's no right one right way. In the back.
Yeah, since we have this knowledge that they wouldn't have in 1936, like that in 1937, the NLRB case, how it really expanded the commerce power, would you say something like, but it's kind of moving back towards...
Yeah, and you could say, but the direction of this court seems to be shifting towards a broader version of commerce. Yeah, that'd be totally fine.
So our answer could be that it would probably be it'll probably pass.
Yeah, I mean that almost becomes like a predictive question, saying based on where the court's going, this should probably be upheld. Yeah, that'd be fine. And you could even reference in live Roosevelt's court packing and what's going on. This is probably where the court's headed. Other questions?
We can add the poultry case here.
How'd you cite it?
In the way that Congress exceeded the power by distribution was not.
Yes. Yes, exactly. Yeah. Chickens were not commerce. Yeah. What else?
I just didn't cite Carter because it was 1936, and so is that...
Yeah, that's fine. Yeah, that's fine. And Carter didn't say anything that much new either. Yeah.
So based off of her question, I mean, can we just assume that if the year is 1936, it's December 31st, 1936?
Yeah, I considered putting a date and a month in it, but I figured no one would even know the date and month these cases were decided, so that'd be keep me more confused.
But we can use
Good.
cases for
Yes.
that year.
Yeah, I mean, the book doesn't give you the day and months the cases were decided, but I did consider that, but decided against it. Melissa?
The other thing is, do you want us to, like you said, like the entire history of the case precedent of commerce clause? Do you want us to do that, or is it okay to cite like the examples of pertinent cases?
I did this because this explains the various modes of what is commerce, right? So I mean, if you could do it with less words, that's fine, right? So I mean, you should talk about Gibbons. You should probably talk about E.C. Knight. I mean, Carter was probably redundant. I probably didn't really need to mention Carter because I mentioned Hammer, because Hammer and Carter are effectively the same, line of reasoning. So you don't need to mention all of them.
I just mentioned Gibbons, Hammer, and checker poultry.
That's fine. What else? Can we move on? Okay. Yeah. Oh, yes, sir.
Yeah, so for Gibbons, is it proper to argue it the other way? So saying that commerce is defined broadly, including intercourse within one state that is intermingled with another state, and then say healthcare is part of, or like regulating healthcare is just in one state, affects every other state?
Oh, yes, and that's the government's argument. Yeah, you can make that point as well. I mean, and that shows me that you internalize the government's Obamacare argument. That's exactly right. What else? Yes, ma'am.
I'm not sure if this is what Aaron was asking because I guess if we're siding with the government's argument, it doesn't matter what side we take as long as we justify it. But that was I kind of had the same question because I interpreted Marshall's broad definition as being broad enough.
And you can say under Gibbons that because health insurance is something that affects state lines, then it is commerce. You absolutely hold this is commerce under Gibbons.
Okay.
In fact, a lot of people in the Obamacare case, Gibbons, that's all you need.
Right.
What else? Yes, sir.
This was based on the answer we had to be solely on but a lot of the jurisprudence at that time was really based on almost like separate realms of responsibility.
Yes. Yes.
So I just don't know how
Well, because I mentioned in E.C. Knight, it was mostly a 10th Amendment case. And also a Hammer as well, they found that manufactured goods are the province of the states. So I mean, during the early 20th century, commerce and 10th Amendment, they were like this. They were BFF. Everyone know, this is the 10th anniversary of Mean Girls, the movie? That's fetch. So, it hasn't happened yet? I'm working on it. I watched. What, you were like in high school when that came out?
I'm as old as you.
Okay. Well, yeah, I remember watching in college. Gee, thanks. Yes. Anyway, I remember I was in college. One of the first I watched on DVD in some small TV. Well, it's Tina Fey. Yes.
Okay, so that's not really going outside.
No, I think that's directly on point because the precedents themselves mention it.
And then what exactly, I guess I'm still looking for some direct and indirect tests. That kind of got overruled during this.
Yeah, I mean, I can explain that later in detail, but effectively, if there was a direct impact on interstate commerce, then Congress regulated. But if it was something like child tax that maybe might cross state lines, that wasn't enough, right? It's possible that the manufactured goods might cross state lines, but that possibly is not enough as it directly impacted. Sorry, anyone other? Yes.
So I kind of argue this is, I kind of took it like indirect test is also substantial test.
That's okay. Yeah, that makes sense. You should tell by now there's a lot of ways to answer these questions. A lot of ways. I write these to be quite open-ended. And I'm always actually surprised because I usually think I know all the different ways people can answer questions, and I'm always surprised. Things always comes like, oh yeah, I didn't think of that. That's good. All right, can I go into the next one? Okay, last one.
Well, I don't know if you'll might inadvertently end up just answering this throughout, but I didn't know what to do with the 3 cases that we were given with the word count. Like I didn't know how to factor that in with my answer.
What do you mean the 3 cases?
Well, saying something about Liberty League. Like I didn't. I'm sorry. Well, like I didn't say anything about the Liberty.
So about standing?
Right.
It wasn't actually asked, but standing is always an issue.
Mm-hmm.
And if you think there might be a potential standing issue, you should probably mention it.
Right.
And it can be dispatched in 1 or 2 sentences. Didn't take long. Okay, last question, then move on.
At the same time, do we discuss like the mootness and all that? I mean, all that. Those things that you mentioned. Like
Well, actually, mootness is implicated in this case. I'm sorry, ripeness is actually implicated.
right.
If an issue is not implicated, then you really don't need to mention it. But if there's actually a potential argument whether standing or not, you probably should mention it. If that makes any sense, right? I mean, there's no question that Roscoe Filburn is son of standing. So I mean, I wouldn't ask you to mention that. But the Liberty League are suing on behalf of a law that impacts individuals. That is an issue. Okay, let's go into the next one. You guys are much more civil than my property people. They were yelling at me. It's okay. So I have to put the word unprecedented in there. Congress is regulating an activity. And I think this is kind of Evan's question. These kinds of things, regulating activity, inactivity, these are usually the prerogatives of the state, not the feds. So this is also something that has never been done before. This was almost my throwaway. Okay. I discussed that necessary and proper. The only case at this point you have on necessary and proper is McCullough. That's all you got. That's it. And frankly, until John Roberts' opinion on Obamacare, that's all we had. Now we have Obamacare. But at this time, all you had was McCullough. So we said that Marshall said that Congress can enact all laws that are necessary and proper incidents to executing federal law, federal power. This is kind of a good thing to mention if you can, that this was the Madisonian sense of necessary was canned, and that John Marshall took the Hamiltonian approach that makes necessary mean convenient, and this is a broad power. So this shows me that you understood the development of the doctrine and how Marshall understood it. Okay, so under HSA, would this actually be necessary and proper? Okay, so I discuss this in the next paragraph. While the HSA mandate is in fact necessary, because this is a convenient means to implement healthcare, is it proper? Well, this also, you can agree with me or not, I don't care. But the argument that Roberts made in Obamacare, which I think is probably right, is that coercing someone to buy a product is not proper, right? Because this creates a separate power which Congress lacks. As we noted above, Congress doesn't have the power to compel people to buy health insurance based on their commerce powers, and necessary and proper can't be a grant of this new great power. Okay? If you also said, McCullough said necessary and proper is broad, therefore Congress can do it as necessary and proper, that'd also be correct, right? You could say the only effective way of implementing national health care is by making people pay this penalty. that's a governance argument, that would also be correct. All right, so questions on the necessary and proper. Yes, sir.
Well, I know that proper wasn't really discussed until the Affordable Health Care Act. Am I, by not mentioning anything about proper, am I just like missing a beginning?
No, you're not. You're not. What would you answer?
I just didn't say anything about proper, but I knew that it had been.
I mean, but what would you write?
Myself?
Yeah.
Well, I said that it probably would be seen. I mean.
Under McCullough?
Yeah, it could be under McCullough.
Because McCullough's very broad and basically
Yeah.
just said, yeah, and that'd be just fine. That'd be just fine. Yes.
So for necessary, what I don't know if this is correct, but what I did was with McCullough, even though the necessary power is broad, I said that because the tax is not actually a tax and it's not actually regulating commerce, it's not necessary and proper to enforce one of the enumerated powers in Section 8. Would that be a right way of looking at it? Or
So effectively, they didn't need the mandate, or they needed the mandate.
So basically, well, like what I'm saying is that it wasn't like you can't say it's necessary and proper to enforce one of the enumerated powers.
Oh, because it's not actually a
Because
tax.
it's not actually part of an enumerated power.
So now we're getting a little bit into the weeds. Technically speaking, if you read Marshall carefully, necessary and proper is actually a separate power. Or even if Congress can't require people to buy health insurance as a matter of commerce or tax, they can do it under the necessary and proper clause. This is Gonzales v. Raich. So even if Congress can't regulate just marijuana grown locally, Congress might have the necessary and proper power to do it to make the drug regulation effective.
Okay,
So this is the meaning of this great and substantive power. Like it confers a separate power, but the limitation that Marshall identifies is it can't be too great of a power.
okay, so then what would be the standard if it's a separate power, like in this case?
Yeah, I mean, we don't know. What the Chief Justice identified in Obamacare was coercion, right? It's coercing someone to buy something, and Congress can't do that. I'd accept whatever standard you come up with. Even if you tell me that there is this separate power, but it's limited, I think that'd be a correct answer. Jared?
I thought that the necessary and proper clause isn't a power in and of itself. It has to be.
If you read Scalia's concurring opinion in Raich, it effectively is a separate power. And I think the fact that Marshall said it can't be a great and substantive independent power, meaning it can be a little power but not a big power, right? So there can be some additional powers granted by necessary and proper. It's not just elastic. I know that's what we're taught, but it actually has been interpreted to confer additional powers. You can see Comstock, you can see Gonzales v. Raich. A little bit too deep into the weeds for a review session, but it's an important point. Yes?
Well, I thought I had a note that in McCullough it says that you have to be like an incidental power of an enumerated. So I feel like that.
Right. I mean, there's that one line in McCullough. It's let the ends be legitimate and let the means be valid, and then whatever they want. Right. That's not what you just said. Right. So opinions, the dicta in Marshall opinion is actually much broader. So yes, that's be incidental, but if the means are legitimate and the ends are valid, then go for it. So as long, and what Robert said was, as long as what makes the ends not valid is coercion. Right, the fact that it's coercion makes the ends not valid, and that takes outside the scope of necessary and proper. Yes, Melissa?
So, are you saying that it can be an independent power, it doesn't have to be related to one of Congress's express powers?
It has to be used in support of that power.
Okay, and that's what Marshall said. He said it has to be legitimate, related to one of the express powers.
Related, but not.
Yeah.
Yes, it's related. Okay. Yes. Necessary and proper. I swear, if you took this class 2 years ago, I wouldn't have said any of this stuff. Obamacare really changed necessary and proper in ways which I don't think most people, even professors, even appreciate how much that changed stuff. Because we now have limits. Okay. Other questions on N and P? N and P. And again, you're welcome to use acronyms N and P. I know what you mean. That's fine. All right, I'll move on. So the next one, taxing power. Okay. This answer, again, I would accept a wide range of answers. In my sample answer, I acknowledged at the beginning that Congress's powers to regulate conduct through tax is much greater than its commerce powers. We've done this a number of times. So I think the most relevant precedent is Bailey. This was one of the child labor tax case. This was the one that came after Hammer. You recall Congress tried to ban child labor goods and Hammer under their commerce powers, and the Supreme Court struck that down. And then Congress tried to place an excise tax on the profits of businesses that use child labor. I think it was like 10% or something. Courts struck that down also. Okay, and why did they strike it down in Bailey? Well, because it said it wasn't actually a tax. This was a way to penalize or punish people, right? And when a penalty becomes so great as a form of punishment, it's now unconstitutional. Okay, this is not the section. Was it section 2? It's not exactly like that, but it's somewhat similar. So what I wrote is it fails as a tax, even though it's not labeled as a tax, because it's coercing conduct, right? This runs right into the Bailey principle. Okay, the fact that it's a form of punishment means it can't be construed as a penalty. Okay, in other words, it can't be a tax because it's basically coercion, and if it was a penalty, it would be punitive. You might argue that $1 a month is too low. I think that's a fair argument as well. I left that open. Okay. All right. What do we got for this one? What do we got? Nothing? Wow. No. Yeah. Thanks, Evan. I got scared for a second. Keep going.
I still don't understand actually some of the constitutional principles.
Okay.
Such as proportionality and
Okay. It's not an exam, but I'll explain it briefly. Before the income tax, Congress was allowed to apportion or lay taxes based on population, but it has to be basically apportioned or distributed equally among population, right? It can't be based on one individual. Okay, that's all you need to know. The problem with the Obamacare tax was it was based on one individual. It's not apportioned based on population. It wasn't separated based on the population of different states. So that it's not an income tax. It's not quite an apportioned tax. It's not really a direct tax. Don't worry about that. It is far beyond what I want you to know. Other questions? Yes.
So on this one, my question is kind of regarding how all the answers pan out together, because what I put, because in my first one I sided with the government,
Okay.
and I said that they could give under commerce and necessary and proper, but then I basically put that Madison draws limitations on giving Congress the power to tax on something they can regulate, and I said that because they can regulate it, or if they can regulate it, then it would seem concurrent with necessary and proper clause. And then once I stopped typing, I was like, wait a minute, now I'm sort of...
You changed your opinion.
I'm crushing my first question.
Oh, I see what you're asking.
So then I said, this would seem concurrent with necessary and proper clause. And
you can give contradictory answers.
yeah,
That's fine.
However, the Bailey case further indicates that it can't be construed in order to disguise it.
That's fine.
So,
I mean, you can give contradictory answers, right? You're not bound.
Okay.
You're looking at this objectively. You're not writing a brief trying to persuade someone. You're looking at this objectively. Excuse me, how you see it.
Okay.
That's fine. Yep, in the back.
Again, I know this question has been asked, but in 1937, Joseph Stone said that taxing power is all you need. Could we tie that in?
Cute. Yeah, it hadn't happened yet, but you might work that in somehow. How'd you decide to work that in?
What did he say?
Justice Stone, remember he told Francis Perkins, the taxing power, my dear, is all you need.
I talked about policy and I said that FDR was trying to bring in.
Yeah, I mean, what year was Helving versus Davis? 37 or 38? Yeah, it hadn't happened yet. Yeah, you can bring that in. I saw a hand, yeah.
The study group I had when we were talking about it after, we had some different answers. One of them was I think, at least I had some confusion between the spending and the taxing power on when the portion of the tax would be coercive or not.
Okay, let's be precise. The spending power, Congress doesn't spend on individuals. They give money to the states. The spending power is spending money to the states. The taxing first individuals.
So for like the Dole case, that falls under spending.
Yes, it's a spending power.
Okay, so that's kind of what I was trying to argue by saying $1 wasn't coercive.
Yeah, no, that's a little confused. The spending power is when they're coercing states, not individuals.
And then also, someone else made the argument that in context of the question, like coming out of the Great Depression, $1 could be looked at.
Yeah, I didn't want to get into inflation, how much it was. I just picked a very low dollar amount, like $1, to leave it, let you go either way with it. I haven't actually. If anyone wants to do the math of what $1 in 1936 is today, I'm guessing it's about $100, maybe. I don't know. I want to do the math. They can tell me. All right. Other things in the taxing power. Okay. This wasn't even relevant, and I wouldn't even ask you to do it, but it was there. There's a non-delegation issue. They basically gave the Labor Department the power to define a qualified healthcare plan without any guiding principles. And under Schechter-Poultry at the time, that was unconstitutional. This is actually correct, because the entire reason why we have Hobby Lobby is because of this. Congress said nothing about requiring birth control pills to be given to anyone. They said qualified health insurance, and they let HHS define what qualified health insurance means, and they included all this birth control stuff. So this is actually the issue in Obamacare, but the non-delegation doctrine doesn't really exist anymore. Yeah.
$16.88.
How much?
$16.88.
So $16 a month. So it's basically, I don't know, $200 a year. That's actually more than the current Obamacare penalty. The current Obamacare penalty is about 85. Oh, so yeah. All right. Other questions? All right. Let's move on. All right. So due process, Fifth Amendment. I mentioned this when we did Atkins, but the 14th Amendment's due process clause has been read in the same fashion as the Fifth Amendment's due process clause. Remember Atkins versus Children's Hospital? This was the minimum wage case from the District of Columbia, right? District of Columbia is the Fifth Amendment, not the 14th. So I hope no one got thrown saying, what the hell? There's no Fifth Amendment in the due process clause. Right? We did this in the Atkins case. So when I'm talking about due process here, I'm talking about individual liberty. And I identified 3 possible claims, which I tried to get everything I can think of, and maybe there are more, because liberty in its transcendent dimensions knows no bounds, says Anthony Michael Kennedy. So I discussed first Meyer and Pierce. It infringes the right to direct education upbringing of a child. This is Meyer versus Nebraska. Also teaching of children, Pierce versus Society of Sisters. My initial draft of the question, actually the school was a party, but I took that out because it was too complicated. But I was actually thinking, does a school have the right to teach? And I think they actually would, because the case in Pierce was brought by the school, not by the students. Okay. Second, I think you have a decent liberty, bodily integrity issue, right? Congress is forcing these poor children to eat broccoli. Okay. Although we do have precedents kind of the other way. We have Jacobson saying that the state can force you to take a harmful vaccine, perhaps. We have the Buck v. Bell case, which says they can sterilize you. And if these cases are good law, and they were at the time, and they remain good law till today, that they can force you to accept this burden on your liberty, then they may be okay. The third one has to do with the general liberty interest in not being forced to do something. Generally, we live in a country where the government can't tell you to do something unless they have a very good reason. And I argue that it would actually be unprecedented for the government to compel you to buy anything. What's somewhat bizarre is this was the actual main problem with Obamacare, right? All this stuff about Commerce Clause and taxing power was kind of an argument. But at heart, people didn't want to be told to be forced to buy health insurance, right? That's what people objected with Obamacare. And at the base level, it was a due process issue. But no one wants to admit that, because once you say due process, you say Lochner, and they start screaming and yelling and going crazy and throwing things at the wall. So they have to frame in terms of Commerce Clause and taxing power. But this was effectively the main issue of Obamacare. If you read Justice Kennedy's the portion of his dissent clearly, this is what's animating it, that people can't be compelled to do stuff. All right. Questions? What'd you get for this one? Yes, sir.
So the way I looked at it is, like, I did use Lochner to kind of say substantive due process for a liberty interest, because you can consume and eat whatever you want. So, like, I kind of incorporated the bodily integrity and, like, right to liberty in that argument. Yeah. And then I said, well, it can be, it can't be upheld under substantive due process under Lochner. But if you look at procedural due process, like Buck v. Bell, where it's just like they can, if they follow procedure, they can do it.
Yes, and in fact, that's a good point. See, the Fifth Amendment has both substantive components and procedural components. That'd be exactly right.
Okay, so like in that case, when there's like 2 sides of it, do I just, because like I just put it as, okay, well, if it's substantive, you can uphold it, this procedural.
That'd be a perfect answer.
Okay, so I wouldn't have to like take a side or one
No.
side or the other.
No, I mean, if you think one side's stronger, you can say perhaps they win under substantive due process, they lose under procedural due process, or the other way around. You can do that.
Yeah, that's basically what I said.
That's quite all right. Yeah, again, this is not a brief, right? You're not trying to persuade me which side's right. You're trying to objectively explain how each side will come out. What else? Other questions? Mm-hmm.
I think when I was walking the test, I had note that I saw, like, you see, there's always a process, like, you see if there's an individual liberty being violated, and then the state's interest is kind of way up against.
You can do the balancing test, right? I mean, I didn't go too far into that, but you could definitely explain, what is the state's interest in compelling people to buy broccoli, right? What is the harm to the individual bodily interest of being forced to consume this horrible leafy green, right? And then you could do that kind of a means and balancing test. That'd be right on. Melissa?
That's kind of what I did. I said that I brought up Jacobson and Buck, and I said basically like unlike in Jacobson or Buck, or even Buck, where it was much more likely that not getting vaccinated would cause disease outbreaks, or even not sterilizing a feeble-minded person would lead to the production of feeble-minded people. There's no hard proof that broccoli promotes health, particularly because people tend to do with products.
Oh, but recall the finding of fact. What did Congress find in the very first line of the Health Security Act? That broccoli is healthful. But I mean, your answer is very good. The connection's weak. Yes. People would broadly. I mean, at that point, they would ban margarine also under the filled milk under the Oleomargarine Act.
Yeah, my point though was the connection is
That's right. Yes, sir.
I just want to ask you, if there's a strictly policy question here. I mean, I know your question doesn't give it, but let's say.
Are you saying due process analysis is policy based? Is that what you're trying to tell me?
Let's say one of these kids is allergic to broccoli. The law is very vague.
There's no exceptions. Yeah.
Right. So I say there's no exceptions there. So how would the court address something like that, where it gives no out for someone who's allergic to broccoli?
You can mention that as a matter of procedural due process. I mean, that's what Aaron said, right? Yeah, I think that's a fine argument. What else? You guys just came up with stuff I didn't think of. I mean, this will happen, I promise. You're going to come up with stuff I don't think of, and it'll be good. Yeah. What else? Okay, I'll move on. Making good progress here. You guys are yelling at me much less than night students. They were getting angry. All right, so 10th Amendment. You'll notice, and this is effectively Aaron's question before, there weren't many straight-up federalism cases in the early 20th century. They were all kind of commerce/10th Amendment cases where Congress can't do this. The main reason why is Congress didn't really attempt to regulate what states did. It wasn't done. That would have been cause for another civil war. So under the 10th Amendment, Congress lacks the power to direct or command the republic, the state of Texas to open these offices and hire these people. This is Evan's point before. Traditionally, insurance regulation has been the province of the state police power and beyond the scope of the federal government. I throw a little Madison there about the importance of having ambition checking ambition, that the federal government and the state governments must have this tension to reduce the risk of factions. Okay. Also, I throw this bit in about Missouri v. Holland. It wasn't really relevant. There's only federalism cases I could think of those straight-up federalism about the powers of the states to infringe sovereignty. It probably wasn't even relevant, but I threw that in there in case anyone was thinking about it. Okay. What do you got for this one? Questions? Yes?
So I said this was sort of like reverse Gibbons.
Reverse Gibbons, explain.
That basically Congress is trying to exercise power that they don't have, and then in Gibbons, the state was trying to exercise power that it didn't have.
That's interesting. I didn't think about it that way.
In regulating commerce.
Yeah, I mean, I see your point. Yeah, that makes sense. What else?
Because we didn't have a lot in it, I actually incorporated the Articles of Confederation.
That's fine.
That started off with the states have the sovereignty and any use of or expansion of, and that this was an expansion of federal
expressly delegated. Yeah, that'd be a very good point to make. Yeah, federalism wasn't that important in the early 20th century because the feds weren't trying to do too much, right? There weren't many cases on this because there wasn't much the federal government attempted to do. Yes, sir.
So I had my notes and I couldn't figure out where it came from. That you operate under the presumption of liberty if Congress is trying to infringe on state's power. And so in that instance, you're doing strict scrutiny, which I know I haven't been invented yet.
Mm-hmm.
But where did that come from that you operate under the
That's more just kind of a theoretical thing. That's not really from any case, but you're welcome to discuss it. It's from a law professor, a friend of mine, Randy Barnett. It's kind of a theoretical thing. That's not, no case has ever explicitly held that. What else?
So you're okay with us bringing in like theories and stuff?
Yeah. Yeah, I mean, yeah. We did a lot of stuff in this class. It wasn't all just black letter law. And I want to show that you learned that. These are different tools you can use to answer questions. I mean, you'll probably say, why is he telling us all this crap on? Okay, now you can answer the question with it. That's what I was building up to. I set the trap, now I can spring it, right? All right, I'll move on. The last part, again, is the policy, or perhaps most policy-oriented question. I want you to try and make something of a persuasive argument here. I mean, you know, not to persuade, but try to identify why Roberts should not switch his vote. And I identify 3 reasons. You don't need to get all 3 of these. Maybe you have others. The 3 they identify is, one is stare decisis, which says the court has to stand by its precedents. Okay. Just a few years ago, the court held that coal and other stuff was not commerce. We need to follow these precedents. Okay. Second, the rule of law. People rely on this. Governments pass laws based on this. People make their arrangements based on this. It would be very dangerous to change things suddenly. To quote my dear friend Anthony Kennedy, liberty finds no refuge in a jurisprudence of doubt, except on gay rights. So then third, we have, I think it's probably the most dangerous issue. If it's seen that the court only changed its vote as a result of Roosevelt's tactics, then Roosevelt could think he can bully the court. And that would be very bad. And perhaps one of the reasons why the court shouldn't change its mind was to perhaps stand up to the president. Of course, you're welcome to write the opposite, that if the court stands up and Roosevelt packs the court, then the entire court becomes a political agent. So we didn't know then is whether Roosevelt would pack the court anyway. Right? Imagine if Roberts changed his vote and Roosevelt also packed the court. That would have been a double blow. This I threw at the end. I can't imagine anyone would actually need to write this, but there's actually ways of taking a more narrow opinion short of upholding the law, right? For example, he could do what John Roberts did and rewrite the statute, treat it as a constitutional tax for purpose of its analysis. Also, there's a standing issue, right? This was the lurking issue in Obamacare. The court could have just dumped the entire issue by saying no one's paid the tax yet, dismissed. They could have dumped the entire issue, and they can simply say it's unright, like a green banana. All right, what do we got here? Yes.
So in this situation where you're asking us a policy question, do you want us to show both sides like you did? Or just like
you can, although when on a policy issue, you should probably account for the opposite argument, just at least.
Because like you're kind of asking us like why he should not change his vote. So,
yeah.
Like I don't know why you go.
Yeah. You don't. For a policy question, you should probably focus on one side, but if there's an easy rejoinder, I mean, think of it this way. If you show me you know both sides of the argument, that's better. Think of it this way. Any brief you write attempting to persuade should acknowledge both sides of the argument. You don't want to be one-sided. That's not a good idea. Sonia?
Can we incorporate also as well the dissents in some of the cases?
Sure. Like which ones? Scalia and Casey?
No, well, I can't remember which dissent that I... Oh, I use a dissent in Prince that the states would be better to incorporate this provision because it would be unreasonable to have federal agents sent to every state.
Yeah. Melissa, your hand up?
Yeah, I also talked about how this would end up like violating separation of powers because basically the president is taking on judicial power.
Yeah, I like it. I like it. Yeah, I like it. What else? What else?
I used ambition, assuming ambition in this part.
That's exactly right.
You say for stare decisis, I kind of like the other way. It's like standing vice presidents. Can you say that it would set bad precedent for future cases?
Yeah, it would set a terrible precedent to change your vote in response to the president's bullying. What else? What other questions you have, and anything?
So if we're using like theories from later cases, not in the same time period, don't list the case name?
Yeah.
Okay.
That hasn't happened yet. What else? Questions? Anything? Yes.
Well, we haven't talked about the other half of the exams of 2014. I mean, do we just basically
Oh, that you're.
need to do anything?
Yeah, I mean, whatever precedents exist today, you can cite. It'll be the same format as this one. It'll probably be a memo of some sort, but you can cite anything that's existed up until the day the exam's decided, or up until the class finish. If the court decides something like tomorrow, I won't test you on it. No, they probably will. Yes. Actually, once when I was in law school, the Supreme Court, I took administrative law. There was an opinion that came out at 10 p.m., and I actually incorporated my answer at 6 p.m. But I'm not expecting it. Yes?
I don't really understand here. I know you said it could be like the icing on the cake. Be knowing the justices, how they tend to decide. And here, since you're saying, like, answer yourself.
Yeah, here that's not too relevant, right? But perhaps in the other question it might be.
Okay.
You'll know if it's relevant. Like, it'll be obvious. Here, if I'm saying be independent, that's not so important. What else?
So just to piggyback on that, when we're including like future cases, like let's say with this one we include like arguments from Obamacare in our arguments for this case, and we don't cite Obamacare, but do you include that as a policy argument, or?
Sure.
Because it's not really law at that point.
Yeah, yeah. You can cite it as a policy argument. Yes.
I know, like in these cases, we know what the future will be, so we can hint at that. If it's like a present case, for example, like affirmative action, and we know kind of where the court may go, you recommend kind of saying like the court's standing this way.
Sure. Yeah. Yeah. What's it?
So if they give us like a specific judge to write to, if we disagree with that judge, do we have to write in a way that corresponds with his view, or can we disagree with him?
You can disagree with him.
Okay, cool.
Yeah.
So it's going to be more of an objective, what do you think?
More likely than not, yes. What else? What else? 56 hours for class, and this is it. Anything else? Melissa?
I want to ask a question, but it's not related to the...
I won't answer any property questions.
No, not a property question.
Okay, what's
It's
up?
from the religious freedom
Yes.
thing. I won't ask you anymore about this. I know that you said that Congress didn't have the power to pass the Religious Freedom Restoration Act through the 14th Amendment. How did Congress have the power to pass it for the purposes of the federal government? Which power did
They're limiting their own powers. There's no Congress can limit their own powers as much as they want.
Okay.
What else?
Just from my understanding, anything we had in print is fair game, correct?
Yes, sir. Books, outlines, printing, whatever you want.
We talked about the incorporation doctrine and the 3 different approaches, but in my notes, for some reason, I only have 2 approaches.
The second one was a Frankfurt one, which only Felix Frankfurter ever adopted, which basically said if it's important to fairness. No one ever bothered adopting it.
Okay.
Don't worry about Frankfurter. It was a hot dog. Yes.
I thought that so wasn't Justice Black for total incorporation?
Black was for total incorporation.
Okay, but I thought that he was the only one that
Right. So basically, Black was for total incorporation, Brennan was for selective incorporation, and Frankfurt basically said none of them except when they're important to fairness or something stupid, which no one ever adopted. Basically, Black won out at the end of the day. Black won out at the end of the day because basically the entire Bill of Rights has been incorporated. What else? Anything else? Going once? Going twice? Well, thank you all very much for a wonderful semester. This was a pleasure for me, and I hope you all enjoyed it very much. Thank you so much. Thank you so much. Thank you. Good luck, everyone.
So you can